Hi, everyone. My name is Zephyr Simonian, and I'm the co-chair of the Armenian Bar Association Student Affairs Committee. The other co-chair is Grant Petrosian, who is in New York. So welcome to this series. We have a three-part series on academic skills. Today, we're going to start off with reading and writing. Then we're going to transition to outlining. And in the third week, we're going to conclude with exam writing. So I'm going to start off with what I think is the most important thing before we get into reading and writing. And also, please ask questions along the way because it allows me to tailor my discussion to what you need. But I want to start off with anchoring, and I don't know if it's a concept that's discussed often or not, because so many people rush to reading a case and then briefing it without forgetting what they're actually supposed to do in terms of what's the context of that case, or why does that case exist, or why is the professor asking me to read that case. So anchoring is just like exactly what you see behind the word. You anchor a rope, right? That's your starting point. That's really what's holding you. The compass is the anchor. It navigates. It's the same thing in law school when you're looking at table of contents and also course syllabus. So I'm going to use a very, very basic example, and then I'm going to translate that to actual law school table of contents and syllabus, and I'm going to show you how that translates into an outline, and then we're going to work our way backwards into reading and briefing. So if you look at the left, the table of contents, it has chapter 1, chapter 2, chapter 3. But in reality, each of those chapters is about a type of animal. So if, let's say, you had never seen this book before, based on what you see, if I were to ask you, what do you think this book is about? You would probably say it's about animals. But then I would ask you, well, what does that book contain? And probably your response would be different types of animals. That's exactly what law school case books or textbooks are. Let's say you're in the book of torts, and then when you open up the table of contents, it's going to show you the different types of tort. So for instance, intentional tort, negligence, strict liability. You would see that as chapter 1, chapter 2, chapter 3. And then within that, it's going to break down into even greater subcategories. So this chapter here under mammals saying there are different types of mammals. Dogs is a type of mammal, a cat is a type of mammal, bear is a type of mammal, and then transition to birds. Parrot is a type of a bird, and then lizard is a type of a reptile. It's the same thing if we translate that to now torts. So we said there's intentional tort. Well, there are two types of intentional tort. Is it a harm to a person or is it a harm to a property? And then if it's a harm to a person, well, what are the different types of ways to harm a person? Is it battery? Is it assault? Is it false imprisonment? So notice the concept is the same exact thing. The table of contents that you're seeing here is a table of contents that you would see in a textbook. And I think oftentimes people ignore that, but really without that, you wouldn't be able to know where you're at. So I'm going to give this as an example under criminal law. So the book is criminal law. The one aspect of criminal law would be murder, right? So you're going to see that in the table of contents. Well, but there are different types of murder. There's first degree, second degree, voluntary, involuntary. So what you want to do is identify what case you're reading and under what category does it follow. So for instance, here, People v. Smith is going to fall under first degree murder. Why is this important? Because when I'm reading People v. Smith, that case is probably going to talk about more than first degree murder. It might touch upon second degree murder. It might even touch upon voluntary manslaughter. But really, the reason why I'm reading People v. Smith is to identify what constitutes a first-degree murder. Those are ancillary issues. So that's important because when you're reading, you're supposed to be reading intentionally and with a strategy in mind. Meaning, I'm really supposed to read People v. Smith to determine, is that case involving facts that would satisfy the requirements for first-degree murder or not? Anything outside of that, that case is not serving any other purpose. And I think that's really important because it makes you very efficient, in my opinion, in terms of reading. Now, some of the response would be, well, Zep, you're not all table of contents are as clear, which is true. Like this to me is a perfect example, right? So it'll give me the list of the different requirements, but it doesn't necessarily list the cases for me, except for the pages. Well, that's when you could go into the page. So if the professor says, okay, you're going to read from 425 to 439, I'm going to identify the case instead of putting it as a page number. I'm going to identify that case and say, okay, Zephyr, I'm only going to read that case for criminally negligent homicide. I'm not going to read it for reckless manslaughter. That part is key because, again, you want to be very efficient. You have a lot of reading. You're probably looking at about 100 pages a day. So if you add up all your courses, you don't have the time to read everything word for word. You're really reading it for the purpose or the category under which it follows. So these are just different examples because some of them, see, like this one would be a syllabus. What you want to do is combine the syllabus with the table of contents. Sometimes there's information in the syllabus that's going to be helpful, and then sometimes that information is only going to be found in the table of contents. What do I mean by that? So for instance, here it's saying that you're going to be learning about assault and battery, and specifically intent and autonomy, which means while I'm reading all my cases down here, I'm only really reading it for intent and autonomy and nothing else. And same thing with some of the sections here. So here, for instance, under session 8, if it's negligence, the standard of reasonable care, you want to look at, okay, what constitutes the reasonable care, standard of care? And each of these cases is addressing the issue of reasonable care. And that's all I'm supposed to look at. So I'm only supposed to look at what's the rule for that, what's the analysis for that, what's the relevant facts for that. So again, here's another example of a core syllabus. This again, just identifying the type of intentional tort and just the page numbers. It's your job to go in and extract the cases that relate to that. So this to me is a perfect example, but very, very simplified. So suppose I was looking at the table of contents and I opened up the syllabus as well. And I saw that in the syllabus, it says requirements of intentional tort. It has to be a voluntary act, and then there has to be intent. And then I also saw that the next day's reading is going to be on harm to person, battery, and assault. But notice in the table of contents, it's not categorizing it the way the syllabus did. My job is to combine it and to make sense of both together. So essentially, I'm creating a big picture outline. That's why anchoring is so important. It's doing two things. One, it's already building the building blocks of an outline. And then the other thing that's really instrumental is that it tells you exactly why you're going to read that case. So for instance, in Cohen versus Petty, it could very well be the case that it's going to also discuss intent. But the reason why the professor wants you to read that case, and also the reason why the textbook or the writers of the textbook want you to read that case, is not for intent, but for voluntary act. Garrett will address intent. Now, again, Garrett could potentially address voluntary act, but that's not the reason why you're reading that case. So you have to have a very tunnel vision when you're reading to sift out all the fluff and the details and get to the heart of the case. Same thing with Paul versus Holbrook and Brooker versus Silverthorne. Again, you're reading the case, you're not supposed to switch it. So if Brooker also addresses battery, again, that's not what you're trying to learn out of that case. You're trying to learn what were the facts that satisfied the elements or the requirements for assault. So pretty much what I would do is before I start a class, I would take the core syllabus and the table of contents, and I would create the building blocks of an outline well before I start reading. I could even do it in chunks. So I could even create it for that week. So for instance, if for that week, this is all I have to read, then this is what I would create as the building block of my outline. One, because now I'm trying to conceptualize everything. One of the pitfalls that you're going to have when you start law school is memorizing. But law school is not about memorization. It's about understanding. And if to understand something, you have to conceptualize it and categorize it. This is what it's doing. I'm looking at the content right now in terms of a category. So for instance, what I'm trying to tell myself by writing this is, okay, I'm in the world of intentional torts. I kind of have an idea that if I looked at the core syllabus as a whole, looked at the table of contents as a whole, there are going to be three big types of torts that we're going to address, one being intentional, two being negligence, and three being strict liability. But for this week, the only thing I'm really going to learn will be intentional torts. Okay, now I'm in this world. Then what I have to see is, what exactly do I have to learn about intentional torts? When I integrate the table of contents and core syllabus, what I learn is that no matter what type of intentional tort it is, meaning whether it's battery, assault, false imprisonment, trespass to land, trespass to chattel, all of those torts must have a voluntary act and an intention or intent. So what this portion is doing here up on top is telling me, Zepier, before you learn the details of each tort, let me teach you the basic foundation of torts. And we're going to start off with Cohen, transition to Garrett. And then what this is also saying is, again, it's conceptualizing the different types of intentional tort. So it's essentially creating this flowchart or big picture umbrella of intentional torts. And under that, well, let me back up. A tort is essentially a type of harm. And this one is saying this type of harm happens to be intentional. Okay, but there are different types of harm. There could be a harm to a person and a harm to a property. The harm to a person is going to have different enumerations or items. It could be battery, assault, false imprisonment, versus the harm to property will be the trespass to land, trespass to chattel, conversion. Once I know that and I've separated those, now conceptually, I can't confuse the two. So when I'm looking later on at an exam and I'm spotting issues, if it was just a harm to a person, I'm not going to spot trespass to land. It doesn't make sense. And versus, again, same thing, if I'm actually trespassing land, I'm not going to say, okay, now I'm going to address battery. Would it make sense? So this is why this part is so important in this process. And also because it's telling me, okay, Zepier, when I read this case, I'm only reading it for that purpose. How does this translate into an outline? So notice I'm already creating the building blocks of an outline and the whole concept of IRAC. Because even if I look back, each of these serves as the issue or the heading on an exam. And then when I open up my outline, but it's the same thing that you're doing in a brief as well, right after the issue, you need the rule. But after the rule, you need the analysis. The cases that you are reading fall under this category. They fall under A. So what I would do is every time I find a rule, and I know that these cases are meant to serve the elements, identify if the elements for battery is met or not met. Under each element, I would say yes or no, or just general rule. Is it met or is it not met? Meaning, does Cohen versus Petty meet or not meet voluntary act? If it does not meet voluntary act, why and what are the key facts? So notice the continuity of what you are creating. All you do, if you anchor from day one, all you're doing pretty much every week is expanding your anchor and turning it into an outline. And the brief is pretty much filling in this part here, the R and the A. So law school is a formula, and you just want to be married to that formula because it could be repeated constantly. So I know if you've started law school, you've already gotten to know IRAC, the whole concept of IRAC, I being issue, R being rules, A being analysis, and then C being conclusion. I'm not going to go into so much detail about this as much as showing you how to read and what that brief would look like. So for instance, here though, facts you do want to cover depending on the professor. So that's another thing I would tell you, especially if you've already started a few weeks in. What's the professor's general philosophy on the amount of facts that you have to put in? Some good kind of rule would be well, who's involved, what's happening, when, where, why, and how do you know, or how did this happen? The issue is crucial. For you to know the issue, you always have to go back to the anchor. So again, I actually don't need to read a case to know what the issue is if I looked at the table of contents. If it's a pretty thorough table of contents, it would already tell me the proposition for which I'm reading. So for instance, if let's say the table of contents said intentional towards harm to a person, battery, and then it said intent, then I know that the only issue the case is really trying to resolve is whether or not there was intent. That's why the table of contents is so important. You don't want to waste your time digging into that case when you could just look at the table of contents and it'll give you an idea of what the issue is. The rule is pretty much what is the definition of the issue? So what is battery? Or more specifically, what is intent? Intent is XYZ. Or you could think of it as how is that issue defined? Or it's giving you a standard. What's the standard for battery? Or what's the element? The analysis, two things I would tell you to look at is what's the court's reasoning? Meaning, why did the court decide a particular way? And what are the key facts that it relied on? Oftentimes in analysis, what you're going to look at is the interpretation or the court's interpretation of the facts. So for instance, if, what's a good example? If, for instance, I hit someone, and let's say it's under battery, and battery is the intentional infliction of physical harm to another person. Okay. The issue is, let's say, harm to another person. Let's say my hitting of that person wasn't direct, but I snatched a purse out of that person. Is that still battery? If it is, how did the fact that I snatched the purse satisfy the element of another person or to the person? You need to bridge the two. That's the analysis. And you bridge the two with a because. And everything after the because should be an interpretation of the fact. And then conclusion, it's the holding. Was the element essentially met or not met? Was the issue met or not met? So one way that I like to show you is how the brief, if you brief properly, can translate into an exam writing, and notice how it mirrors an outline. So battery is your issue, which is the issue that you would have in your brief as well. Then you'd have the rule, which is the harmful or offensive contact of a plaintiff's person with intent and causation. And then every element will have its sub-element. Every sub-element would have its own rule or definition. And then every rule or definition will have an analysis where you're either saying, where you're demonstrating if that element is met or not met, or is that definition satisfied or not satisfied, and then you have a conclusion. So again, big picture, notice you have the subject, which was tort, you have the issue, which was intentional tort, you have battery, which is the sub-issue. And again, you have the issue, the rule, the analysis, and then the conclusion. In that case here where it says as an Alcorn, that's essentially what you're doing in your brief. You're trying to understand why is it that in Alcorn it did or did not constitute harmful or offensive contact. Very quickly before I transition to reading a case and then demonstrating the brief, I do want to talk about supplements. I think that supplements are helpful as long as they supplement and not replace the reading of the case. If you drop the case or drop your textbook and only go to supplements, you're never going to understand. The supplement is there to enhance your understanding of the case law. It is not there to tell you what the case law states. In fact, in practice, you're not really going to have a supplement like this that's going to tell you what the case is about. You're going to have to read the case. So you only want these supplements to really further develop what you've already understood from the case law. And I think really what this helps you most with is the analysis in preparation for exam writing. So what I'm going to do now is focus on this here. And I'm going to use Cohen versus Petty as the example, which I don't know if you could see. So I'm actually going to stop share and share this screen instead. And then Mira, if you have questions, please unmute and let me know. Okay, so here, all of this information here is helpful, I guess, in class. If the professor, I would really try to figure out how much does the professor care about procedural history? Meaning, where was this case? Where is it being appealed from? Where is it now at the appeal? Who are the parties? This is just foundations to the case. To me, the meat of the case is once you get here. So I'm going to show you now how I would read this case and how I would break it down. So I know from the outline that I had shown you that Cohen versus Petty is going to be about voluntary act. So I know that I'm in the world of intentional tort, which means that some harm has happened to a person. But the issue is whether or not it was voluntary. Because if it wasn't voluntary, then the person never committed a harm. Let me clarify. Not that they didn't commit a harm, it's that they can't be liable for that harm because it was not voluntary. But now what I need to figure out is, well, what is voluntary? Because how do I know if an act, there's always going to be some act. Every act is always going to have a consequence. But how do I know if I'm going to be held responsible for that act or not? And they're saying, look, you'll be responsible for it if it's voluntary. But how am I going to be able to decipher what's voluntary versus involuntary? So oftentimes cases will start off with a background. They try to go in that IRAC, but IRAC, the I being more what's the issue or what are the facts involved, then the rule, then the analysis, then the conclusion. But sometimes it's all over the place and you just have to find it in the clump. So you'll in paragraphs, you'll still be able to identify I, R, A, and C, but not necessarily in the same order. So here essentially it's saying that plaintiff's declaration alleged that on December 14, 1930, she was riding as a guest in defendant's automobile. That defendant failed to exercise reasonable care in its operation and drove it at a reckless and excessive rate of speed so that he lost control of the car and propelled it off the road against an embankment on the side of the road, as a result of which plaintiff received permanent injuries. The trial judge gave binding instructions and the plaintiff appeals. So what I like to do is after every paragraph, maybe on the side, just write, okay, what's this takeaway or the summary? Again, because I know that it's about voluntary acts, I'm going to skim through this portion very quickly and just say, okay, bottom line is there was a car accident. There's a claim that the person was reckless, but we need to figure out, is this person going to be liable for this car accident or not? Then there were 4 eyewitnesses to the accident, namely plaintiff and her sister on one side, and then defendant and his wife on the other. All 4 were occupants of the car. Defendant was driving the car and his wife was sitting beside him. Plaintiff and her sister were in the rear seat. Plaintiff is a retired school teacher and defendant is a real estate agent who attended to her property and collection of her rents. Notice again, these are all just backgrounds, not so important for me. It's more to create a narrative and a story, but not relevant to why I am reading this case. They had known one another for a number of years, and plaintiff and her sister frequently drove out in the country with his defendant and his wife. On the occasion of the injury, defendant called at plaintiff's house pursuant to an engagement, and plaintiff and her sister got in the car, which defendant then drove to his own house, where his wife got in, and the party proceeded through Washington to Silver Spring, and thence out to Colesville Pike. After passing the country club and when somewhere near 4 corners and 5 or 6 miles from Silver Spring, the car suddenly swerved out of the road, hit the abutment of a culvert, and ran into the bank, throwing plaintiff and her sister through the roof of the car onto the ground. Again, this is only to tell me, look, there was an accident here. Here were the people involved. So if I'm going to summarize this or even put in a brief, all I'm going to say is car accident, 4 people involved. They know each other, max. That's it. There's no real fact that I really need to get out of that. So plaintiff's sister estimated the speed of the car just before the accident somewhere between 35 and 40 miles. And plaintiff herself, who had never driven a car, testified she thought it was nearer to 45. So this might be important because the issue of voluntary, we don't know yet what the definition is, but also up above, there's a claim of being reckless. So the speed limit's going to matter, right? Was the person really speeding or not? 35, 40, depending on where you're at, might not be that fast. The place of the accident was just beyond a long and gradual curve in the road. Plaintiff testified that just before the accident, perhaps a minute, she heard the defendant, who, as we have said, was driving the car, exclaim to his wife, "I feel sick." And a moment later, heard his wife exclaim in a frightened voice to her husband, "Oh, John, what is the matter?" Now, if I'm going to the issue of voluntary, and maybe here's where I would say how you could use a supplement. I would take out any of those books, including from Barbary. So Barbary actually has free materials for 1Ls online and outlines for every single one of your doctrinal courses. I would take that out, or any of the supplements, and just find the rule for voluntary act, so that when I'm reading this case, I could start spotting the facts that would relate to the issue of voluntary act. So here, let's say, I don't know yet what voluntary means, but you do want to rely on common sense too. Voluntary pretty much is, at least without knowing the legal terminology yet or definition yet, is whether or not I have control or will over what I'm doing. Well, if the person says, "I'm sick," and a moment later, the wife says, "What's the matter?" and right immediately thereafter, the car left and the car crashed, you wonder, did he have control? Especially since he said he feels sick. So pretty much what I'm trying to figure out now did the sickness attribute to the accident? Or did he have control over his, faculties and his motor skills, apparently, in essence, to cause the accident? And then she said her sister who testified could not remember anything that occurred on the ride, except that at the time they passed the country club, the car was being driven about 35 or 40 miles. So again, consistent, relatively safe, nothing reckless. The road was concrete and wide. That's another key fact. So the person was driving within speed limits, more or less, on a wide road. It's not bumpy. It's a clean, safe road. And then all of a sudden, she heard defendant's wife exclaim, "What is the matter?" And instead of looking at the driver of the car, says she continued to look down the road and as a result did not see and does not know what subsequently occurred, except that there was a car crash. Now, defendant's evidence as to what occurred just before the car left the road is positive and wholly uncontradicted, meaning they're all on the same page, they're all saying the same thing. So within speed limit, wide, safe road, safe driving, everything is there. And consistently, they're all saying that they heard the same thing, that he said, "I feel sick," and the wife is saying, "What is the matter?" And his wife, who was sitting beside him, states that they were driving along the road at a moderate rate of speed, which again, 35 to 40, 45. And then all of a sudden, the defendant said, "Oh, Tree, I feel sick." Defendant's wife's name is Teresa, and he called her Tree. His wife looked over and defendant had fainted. That's another key fact. So one is, he says he's sick. She asks, "What's the matter?" And then he faints. His head had fallen back and his hand had left the wheel. And I immediately took hold of the wheel with both hands. And then I don't remember anything else until I waked up on the road in a strange car. So these are key facts. These are key facts that are directly related to the issue of whether or not his behavior or his action was voluntary or not. So the witness testified that her husband's eyes were closed and when she looked, and that his fainting and the collision occurred in quick sequence. That's key, because again, they're trying to figure out, well, what's causing it? And if it happened simultaneously, that means he did not have control at all to be able to stop. The defendant himself testified that he had fainted just before the crash and that he had never fainted, and that as far as he knew, he was in good health, and that on the day in question, he had late breakfast and had no luncheon, but that he was not feeling badly until the moment before the illness. Again, this is key because what they're trying to get at is, well, did you know you were feeling sick? Because if you knew that you were feeling sick, at that point, you actually had control over your action. So even though later on you fainted and then you crashed as a result, it doesn't matter if you had knowledge that that's where you were headed. And knowledge in multiple ways. Knowledge, one, have you ever fainted before? The answer is no. Okay, if you've never fainted before, how would you have control over that behavior? Two, that he had never fainted before. Two, that he was in good health, meaning besides the fact that you've never fainted before, has there ever been an indication that you're an unhealthy person or that you've known to be unhealthy? Because if you're unhealthy, then potentially this could have been a cause. So for instance, epilepsy. Yeah, perhaps the first time you have epilepsy or an episode, you won't be liable. But if thereafter you know that you've had a prior history or incident, and yet you still get in the car, you have control over your action, even if it's not until later when you have the same episode and then that results in a crash. Same thing with drunk driving. Some people, can always come back as a defense and say, look, but I was drunk. My mental faculties weren't there. I wasn't seeing straight. I didn't really have control over my actions. And the response is that's irrelevant. Your control over your actions began when you decided to drink and when you started drinking overboard. That's where you had the control. Because otherwise, how would you be able to hold anyone liable? So that's why this prior knowledge is so important. One, the simultaneous action where the fainting and the crashing were pretty much simultaneous. And then two, that there was no prior knowledge. Notice how all of these facts are essentially hinting at a rule. I don't know the rule yet, but if I know that I'm anchored under voluntary act and I have more or less a common sense idea of what voluntary act is, then I kind of have an idea of what these facts are touching on as it relates to the rule. And then he explained the incident as follows. I was going along, just casually along, and I said, tree, I feel awfully sick. And with that, I went back like that, indicating. I just remember my hands getting away from the wheel. I did not have time to think of anything, of any danger or anything else. I just fainted and passed out. So this is truly the key paragraph that, notice, compared to how I was reading everything else, I didn't spend so much time, but here's a paragraph that I'm really sitting on. That's why, again, that anchoring is so important, because it shows you where to spend time and where to just move fast. The other testimony, that of a woman who arrived shortly after the accident and conveyed plaintiff and her sister to the hospital, and that of a physician who testified generally with regard to fainting spells, is not material. So the sole question is whether, under the circumstances, the trial court was justified in taking the case from the jury. We think its action was, in all respects, correct. So here is where, again, I think your professor is probably going to spend a lot more time in class. Like, what does it mean to take the case away from the jury? So for those of you who are also going to be studying civil procedure, it's essentially addressing motion for summary judgment, meaning this is not a triable issue of fact that needs to go before the jury for the jury to decide. Everything is uncontested, essentially. There's nothing, or uncontradicted. There's nothing that really needs to be presented for the jury to dig into the facts and determine which fact is the one that it should rely on. Because here, pretty much all the testimony is the same, and there's really nothing to litigate. And so it's saying, undoubtedly the law that one who is suddenly stricken by an illness, which he had no reason to anticipate while driving a car, which renders it impossible for him to control the car, is not chargeable with negligence. So again, notice what I was saying before in terms of why anchoring is important. They said they're essentially saying this rule is for negligence. If you didn't anchor, and if you didn't look at the table of contents, you might dismiss this, even though this is the rule for the facts of this case and the rule that you need to know. Because we're not, yes, this is about negligence as the main cause of action. But what I'm reading for, which then I'm going to use later on in the exam, isn't for negligence, it's for whether or not the person had voluntary act. But the key here is something voluntary or not? Well, something is voluntary. It is not voluntary if the person is suddenly stricken by an illness and has no reason to anticipate, and it is impossible for him to control his action. What I'm doing is synthesizing the rule. Cases won't necessarily give you a rule verbatim that matches up with your goal. What you want to do is take the key components from the rule and synthesize it to pretty much the main issue or the anchor. So the key thing, and this is, again, if you look at these facts, it matches up perfectly with these elements. One is it sudden? 2, is there reason to anticipate? And 3, is it impossible to control? And that impossibility to control is at the heart of whether or not something is voluntary. But the court has gone a step further and said, look, it's voluntary or not voluntary if it's sudden and the person has no reason to anticipate. Meaning, do you have knowledge or not? And in the present case, this is application. So when you see here, or when you see in the present case, that's a signal that now the court is applying or analyzing. The positive evidence is all to the effect that the defendant did not know or had reason to know. Again, I could use this as a rule that he would be subject to an attack such as overcame him. Hence, negligence cannot be predicated in this case upon defendant's recklessness in driving a car when he knew or should have known of the possibility of an accident from such an event as occurred. As the plaintiff wholly failed to show any actionable negligence prior to the time the car left the road, or causing or contributing to that occurrence, and as the defendant's positive and uncontradicted evidence shows that the loss of the control was due to the defendant's sudden illness, it follows that the action of the lower court was right. Even if plaintiff's own evidence tended more strongly than it does to imply some act of negligence, be insufficient to sustain a verdict. That's why technically it's saying, look, it's a slam dunk case on a motion for a summary judgment because it doesn't need to go to the jury. Although I think on this one, what they did is they went to the jury and then they removed it from the jury's hand. That's different from an MSJ, but same concept. What I want you to see is the matching of the facts to the rule. So sudden stricken by illness, no reason to anticipate, which causes a loss of control. I could go to each fact and match it up with each element. That's your job when you are briefing. So for instance, what you could do is put in voluntary act, specifically Cohen versus Petty. And then you're going to have the facts, the rule, the analysis, conclusion, or holding. You could expand it to the issue if you want a full issue statement. I'm going to show you. And sometimes your professor is actually going to want a procedural history. Meaning, can you outline the journey of the case from trial to appellate? What happened at trial? Why is it at appellate? The facts really, I would always work my way backwards. I would start off with the issue. So here the issue, and the best way to write an issue statement is one that allows for a yes or no answer. So did a defendant act voluntarily? When? And what you want to do is bring in all of the key facts. This is the legal issue. Then plus a when, plus what's the factual issue. What are the key facts? When he never fainted before, didn't feel sick prior, had eaten a good breakfast, and crashed immediately after fainting. So the rule is voluntary act is one, or I could say a person does not have prior knowledge of an illness and has control over his or her actions. And then here is where you're going to show how the person had, there was no prior knowledge. And so I could even break it down. No prior knowledge, right? So never fainted before, was well. He, and this is where I could go back and look at all of these facts here. Actually, I just realized, don't know if you could see my screen. Let me try it one more time. Between this and this here. So no, he never fainted before. He was well, ate well so that he wouldn't have, he couldn't have been lightheaded, etc. And then no control is he crashed right before he fainted. And then the explanation of how are you connecting these two? And then so then the key facts, I can make it very brief. D crashed his car on a curve. A road was wide and safe. You could give any amount of detail that you want. Most of this should be here, should be in the facts. And then the conclusion is if you do it in a statement that can lead to a yes or no answer, then the answer would be no. And then if you need the holding, so you could even separate conclusion from holding. Upheld, or you could say appellate court upheld. And that's it. So the whole process of briefing should be simplified, and the process of reading if you anchor properly. So how does this translate to class? What you want to do in class is identify, you have two choices. You could either take the brief, let's say this brief, and then add the notes in red. So you could say professors relied on these facts, and then emphasize it. Or professor gives you hypotheticals. You could add it directly onto your brief, but in a different color so you could see the difference. Or you could create a separate document going through the briefs in class where you're pretty much redrafting the briefs essentially in class. And then afterwards, you're combining the two. When you combine the two, pretty much what I think you need to create, and where did that version go? Oh, here. Is something like this. Every day after class, you should start drafting the building blocks of your outline. So again, if I'm at voluntary act, here's the issue, here's the rule. And it was no, the act was involuntary, here are the key facts. And each of these facts directly addresses whether it was foreseeable, awareness, or had consciousness or control. That's it. So imagine just how many times you are doing the same thing. You are touching the same content multiple times, which is precisely why you never need to memorize. If you're touching the same content that many times, at least the anchoring, that's 1. Reading, that's 2. Briefing, that's 3. In class, that's a 4th time. And then if you synthesize your notes, that's 5 times that you've touched on the same case, the same rule, the same issue. For that reason, you don't ever have to memorize. By the time you get to the end of the semester, you have already memorized it because you have looked at it or worked on it so many times. So that's pretty much the overview of what I wanted to show you, from anchoring, the reading and briefing, to synthesizing the information. Because remember, what I did essentially with that main ultimate outline is I started from the anchoring. I already had that foundation. All I did was pop that information in there. If you do that every night after class, and then on the weekend, you're reviewing that, you're pretty much studying for the exam from day 1. The other thing that I would recommend you do, this is my philosophy, but you can differ, is read on the weekends because you have more brain energy, and do more of the synthesis on the weeknights. So pretty much what I used to do is I would read all of the cases for the week over the weekend, so that on the weeknights, all I was doing was that last part. Some of you might not want to do that. So another thing you could do is read at least 2 days ahead of class. So for instance, for Monday, you would read on Saturday or Friday preferred. Then for Tuesday, you would read Saturday. For Wednesday, you'd read Sunday. You could do it like that too. But just know then that you're going to be doing multiple functions at the same time. I just like to separate my brain and compartmentalize it, because I want the synthesis is engaging more with my critical thinking, and reading is engaging more with mining the information. And that's also a lot of words, and I have a lot more time. So I have over 8 hours on a weekend that I don't get during the week. So for that reason, I like to jam everything on the weekend so that my brain could rest during the week, because my brain's already getting a lot more information in class, and because it's also going to need to synthesize afterwards. So that's more or less how I compartmentalize. But you have options as long as you're always reading ahead, at least 2 days ahead, if not more. Any questions? Because that's all I wanted to present for this session before we transition to outlining next session. But any questions? Okay, so then what we're gonna do is the next time we come back, we're gonna discuss outlining and really how effective, you're gonna test the effectiveness of your outline by looking at an exam and seeing if you're able to spot the issues properly or not. So with that, I'm gonna conclude this session. Have a wonderful rest of the day, and we hope to see you next time.